Assalamualaikum warahmatullahi wabarakatuh. Good morning. Thank you for coming to this presentation. An honor to meet you here. Let me introduce myself. My name is Indri Aprianti from the University of Nusa Putra, majoring in law. The purpose of this presentation is legal studies on acquisitive verjaring of land based on Indonesian civil law to fulfill the 15th session of Business English course assignment and for final exam project assignment. Okay, next. Number one, there is decade or overdue. Definition of decade. The expiration is the final deadline for obtaining and or relinquishing a right lawfully. The final deadline for obtaining and or waiving a right is the last time limit for obtaining and or relinquishing a right lawfully. Okay, next. Number two, there is various decades. Number one, decade of obtaining or acquisitive verjaring. The decade of obtaining or acquisitive verjaring is overdue as a way of acquiring title to an object. The condition of this decade must be in good faith from the party who controls the object. And number two, there is the decade of liberation or extinctive verjaring. Each a person can be exempt from a chain or lawsuit due to overdue. Okay, number three, there is the cause of the decade. Number one, Article number 19 and 78, decades are prevent when the enjoyment of the object for more than a year is snatched from the hand of the powerful, whether the one who says it the old owner or the one who says it a third party. Number two, Article number 19 and 79, the decade was also prevent through a warning, a lawsuit, and by any act in the form of lawsuit, one and another given by the employee in power for it on behalf of the party entitled to the person who was to be prevented from obtaining it by the way of the decade. Number three, Article number 19 and 18, the plaintiff was a pawn of an insurance judge preventing decades. And number 4, Article number 19 and 81, but decades are not prevent if the warning of suit is withdrawn or declared void, neither the plaintiff dismiss his claim, nor the claim is rejected by the judge, nor the suit is declared for void due to the lapse of time. And next, number 5. Article number 19 and 82, recognition of the right of the person to whom the decade goes, which is done by word or deed of deed by the powerful or the debtor, prevents also the decade. Number 6, Article number 19 and 83, annotates under Section 19 and 79 to one who owes a liability basis or confession of the person prevents the development of the person in debt, nor to the heirs of their heirs, annotates made to the beneficiary of a debt on a liability basis, or the recognition of such heirs is not to prevent a decade again the other heirs of the heirs, not even in the case of a mortgage debt, except when the engagement is indivisible. And number 7, Article number 19 and 84, notice made to the principal debtor or the recognition of this person prevents the decade again the insurer of the debt. And number 8, Article number 19 and 85, the decade-long prevention carried out by one of the debtor in a bearer agreement applies to all persons who are also in debt. Okay, next. There is the cause that suspend expiry are number 1, immature people. Number 2, people who are under guardianship. Number 3, people who are still tied to a conjugal relationship. And number 4, receivable that can be collected within a certain time and the predetermined time have not passed. And number 5, the heirs of the deceded person, e.g. widow or duda. Next, there is decade limit. Number 1, the law is the limit of the decade whose determination has been reguled in the legislation. Determination of time limits according to the law in general, its provisions regulate the limit of expiration of the decade whose determination is based on law and regulation, both laws of a general and special nature governing the decade. And number 2, according to the agreement of the parties, namely with the end of the decade according to the agreement of the parties is the limit of the validity of the decade whose determination is regulated in the agreement that has been agreed upon by both parties. Okay, next. Number 2, there is title to land. Definition of soil. Soil in juridical sense is the surface of the earth. The meaning of the surface of the earth is a party of the land that can be judged by any person or legal entity. Therefore, the right that arise above the right to the surface of the earth, including buildings or object contains on it are a legal matter. The legal issue is question is a matter related to the adoption of principle related to the relationship between land and plants and the buildings contained on it. Definition of land rights. Land rights are rights that authorize those who have the right to use or benefit from the land they judge. Article number 4, paragraph 1 of Law number 5 of 1916 concerning the basic regulation of agrarian principle defines land as the surface of the earth. Thus, the right to land is a right to the surface of the earth. Okay, various rights to land. The types of land rights referred to in Article number 4 of the Basic Agrarian Law are further specified in Article number 16 of the Basic Agrarian Law, namely, number 1, proprietary, business use rights, building rights, variable rights, leasehold rights, land clearing rights, the right to collect forest product, and other rights. Other rights that are not included in the aforementioned rights that will be stipulated by law as well as rights of a temporary nature as referred to in Article number 53 of the UUPA containing temporary land rights, namely, number 1, mortgage right, profit sharing business right, right to ride, and farmland lease right. Okay, and next, grouping of land rights into group. Number 1, primary land right. Primary land rights are rights to land grants by the state, including property rights, business use right, building use right, and use right grants by the state. And number 2, secondary land rights. Secondary land rights are those derived from the right of other parties, including building use right and use right grants by landowners, land rights, profit sharing business right, hitchhiking rights, and lease right. Okay. Land right can be abolished if number 1, delete it because it expires its term, number 2, cancel because of a condition not being met, number 3, doesn't franchise, number 4, voluntarily released by the owner, number 5, displaced, and number 6, overdue is general. So, the conclusion is the application of decades in obtaining land rights according to civil law in Indonesia is seen from the prevention for the abolition of property right to land according to law number 5 of 19 and 16 concerning the basic regulation of agrarian principle, one of which is caused by the fact that the land is abandoned by the owner, while in the sense of being abandoned is by looking at the fact that the land is not used and left alone for a long enough period of time so that the land is long enough unclaimed. Okay, maybe that's all I can say. Thank you for your listening. May all that we have shared be beneficial for all of us. Wassalamualaikum warahmatullahi wabarakatuh.